So if there's no reason to suggest that he was under the influence at the time or his psychosis was caused by it, then it would not be relevant.
Okay, so no witness is going to say that his underlying mental health issues were caused by his illegal drug use? No?
Dr.
No.
Mayer will indicate that he believed that his psychosis had been going on for a while and was exacerbated by the use of illegal drugs, but he has no knowledge about, at the time that the crime was occurred, whether he was under the influence of drugs or not.
And he's your expert, right?
Right, and he specifically says unless there were evidence that were within a couple hours, usually a couple days, or that he was a chronic user of LSD or shrooms, the appropriate term for that, it wouldn't have affected him, and there is no evidence of that. So we're including, obviously, it from being elicited on cross-examination, there's no evidence to suggest that it affected his mental state at the time.
Okay, Mr. Ellis, do you want to be heard on that?
Judge, I'm trying to remember, I don't have the PCLR in front of me, but that might have one of the categories of the PCLR as well that we talked about.
No. Drug use?
It's going to be hard to separate it, Judge, because every doctor had to eliminate drug use as being a factor in this case, so they all looked at it, they all analyzed it, and he has a history of drug abuse. Several of the doctors, and Dr. Lazaro diagnosed him with different types of drug issues, so
Well,
it's going to be hard to separate it.
you don't want them to do that either, Ms. Manuel? Say, well, you know, we had all these indications of drug use, but had nothing to do with his psychosis. Is that so?
I think if they need to, in order to fully explain their diagnosis, everything they diagnosed him with, if the court's going to hold that they should be able to say everything they diagnosed him with, then I don't have any objection to them saying that they diagnosed him with substance use disorder in remission, but which is what they've all diagnosed him with because he wasn't using anything at that time. So again, it would seem like it's not relevant to his state of mind at the time if he's subsequently been diagnosed with that.
Okay, is it relevant to his state of mind at the time, the diagnosis of substance abuse disorder? Because if it's not, then I wouldn't think it would come in.
Well, we're all relying on his self-report, unfortunately, which is that he did not use drugs. The day of the murder, of course, his self-report is different to different doctors about when he actually stopped using those drugs.
I understand, but you know what I'm getting at.
Right. Well, I'm not going to mention opening. I had no plans on doing
Okay,
that.
well, yeah, but it's a broader picture. I mean, if his substance abuse disorder is not relevant to his state of mind, I don't think it should come in. And I understand the difficulty in establishing that they looked at all these drugs and came to the opinion that it wasn't relevant as to his state of mind on the day of the murder, nor was it relevant in any regards to abnormal brain function. It would be kind of weird. I mean, I guess they're just going to say there's no, I mean, what?
Sorry, I just noticed
What's not out? Oh, that's okay. We're good. Can you call?
I just wanted to bring it up.
Yeah, I'll have.
I can call her.
Can you call the blue man? Thank you. It's going to be kind of weird, though. I mean, are they just not going to talk about drugs at all?
Well, Judge,
I mean, is that what you're asking me to? I mean, they'll just say he didn't have a substance abuse disorder at the time of the offense, and that's it.
what we're trying to keep from happening is in these doctors saying, well, when he was 16, he was high on coke. Well, so what? Well, I needed to look at that in order to rule that out. Well, we can't unring that bell. Oh yeah, when he was years earlier, he smoked spice a lot.
I agree with that, but it's what you're asking me to do, which I may have to do, is the expert does not testify about substance abuse disorder except to say there's a lack of it which is relevant to this. Is that what you want?
Yes.
You want to respond?
Judge, it wasn't just when he was 16. It was, and different drugs, meth, spice. Unfortunately, if there was a test, there's no real testing for spice in someone, so the doctors have indicated that he had that polysubstance abuse that was part of his personality. Now, Whether they say it was effective at the time, that's up to the experts to make that decision. There's several witnesses who are gonna say, we did drugs with him. So I guess they're not gonna ask those witnesses if they did drugs, because that would certainly open the door to all of that.
And I would also add that, you know, there was a lot of discussion about him self-medicating with drugs, some of these different issues that he claims to have.
Since he wasn't taking his prescribed medication, he took other things instead.
Okay, well, it looks like I'm gonna have to do a proffer. So can you stay away from that in opening argument?
Yes, of course.
Okay. So I'll reserve on that. The admission of any evidence or testimony regarding the issues raised in the, okay, so, obviously. So that's it, that's the only thing we have to cover right this second?
Yes, ma'am?
Okay, and then do you want the defendant's right to remain silent read as part of the,
Yes, ma'am.
okay. All right, are we ready? Have the jurors brought in?
We have them all.
Okay. State's ready to have it sworn, right?
Yes, sir.
Judge, we would ask the court to inquire if they viewed
Yes.
or read anything over the weekend.
Yes.
And also, we'd ask to invoke the rule.
Roll and vote. Do I need to do anything about that?
No, but I need a minute to talk about witnesses.
Okay.
Chair.
You're doing the opening right, Ms. Manuel?
Yes, Your Honor.
Mr. Bowman, I don't
Yes.
think you would do this. Can you hold up just a second? I don't think you would do this anyway, but in your opening, when you go through the, psychopathy. Somebody help me with that word, I can't.
Psychopathy.
Psychopathy features, you wouldn't be name calling, you know what I'm getting at.
No.
You know, he's a callous, you wouldn't do that anyway, but
I was going to just briefly define that as someone who is impulsive, callous, lacking in empathy,
period.
period.
Okay. And like I said, I can't imagine you doing that, but, okay, we're ready.
And we are objecting to that, obviously.
I understand.
All right, Deputy Register, I'm going to bring it in.
Judge, can that serve as our objection now, instead of interrupting his
Mhm.
opening? to that.
Oh, wait a minute.
Just over your chair.
Oh, okay. Oh.
Good afternoon, ladies and gentlemen. My first question is, was anybody exposed to anything they shouldn't have been? Media, radio, your friends, the newspaper, Twitter, blogging, Instagram or whatever it's called, Snapchat, any of those things about this case? No? Okay. You're all going to rise and the clerk is going to swear you in. Thank you.
You can raise your right hands. You do solemnly swear and affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence, so help you God.
Thank you. You can all be seated. I'm going to read to you the preliminary instructions in this case. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus John Jonchuck Jr. This is a criminal case. John Jonchuck Jr. is charged with murder in the first degree. The definition of this charge will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It's the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against John Jonchuck Jr. in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their closing arguments. Following the closing arguments by the attorneys, I will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You shouldn't form any definite or fixed opinion on the merits of the case till you've heard all the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence on the law. I now instruct you not to communicate with anyone, including your fellow jurors, about the case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You can't do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, I will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you're on the jury trying the case and ask the person to stop. If he or she persists, leave at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Don't take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or other device is off. At the end of the case, while you're deliberating, you can't communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other devices. If someone needs to contact you in an emergency, the court can receive the messages and deliver them to you without delay. The case must be tried by you only on the evidence presented during the trial in your presence and the presence of the defendant, the attorneys, and the judge. Jurors can't conduct investigations of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to the case or the people and places involved. This applies whether you're in the courthouse, at home, or anywhere else. You cannot visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So don't let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Don't send or accept any messages related to this case or your jury service. Don't discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. These rules are imposed because jurors have to decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That's contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates the restrictions jeopardizes the fairness of the proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate the rules, you can be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you shouldn't speculate on the reason why it's made. Likewise, when an objection is sustained or upheld by me, you can't speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the lawyers out of your hearing to discuss matters that require consideration by me alone. Excuse me. It's impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. And with that said, everybody has a pad and a pen. That's obviously for taking notes. If you're a note taker, you will probably need many pads and many pens throughout the trial. Don't be so consumed taking notes that you actually miss part of the testimony or would miss the demeanor of the witness that might be important. You're free to take as many notes as you want. You don't have to take any notes. That is totally up to you. At the end of the trial, they're shredded, or you can take them home. Nobody reads them. I don't read them, the lawyers don't read them, they're putting a shredder in the back. So you don't have to worry about your privacy being invaded because someone's going to get hold of your notes or read your notes. I guarantee you that won't happen. No one juror's notes take precedence over some other juror's notes or another juror's recollection. So with that said, Mr. Bowman?
Please, the court, counsel, members of the jury, good afternoon. We're here today because on January 7th, 2015, a police officer named William Vickers was returning home from work. He had just worked a full shift at the St. Petersburg Police Department. He'd put in a long day, and he was going home his normal route, which for him meant 275 south toward the Sunshine Skyway Bridge and then on to home. In just a little while, Officer Vickers is going to come into this courtroom and he's going to take that stand right there. And he's going to tell you about what he witnessed on the night of January 7th, 2015. He's going to tell you that it was a cold January night. For Florida, it was a cold night. It was in the 40s. The wind was gusting. The water was choppy. For Florida, we know that's pretty cold. He's going to tell you that as he approached the Pinellas Bayway exit, he sees a white PT Cruiser. The cruiser is driving erratically. It passes him at a high rate of speed, almost causing a collision between himself and another vehicle on the road. And he immediately, going into his training and his police officer mode, begins to suspect that this white PT Cruiser is maybe a stolen vehicle. A few seconds later, he sees the white PT Cruiser come to a stop on the top of the Dick Misener Bridge. This is at the very tip of Pinellas County. The Dick Misener Bridge is a large bridge, about 70 feet. There's water underneath of it that goes from east to west, that goes out into the bay. And just south of the Dick Misener Bridge is a toll plaza for the Sunshine Skyway. And then beyond that, going south, the actual main span of the Skyway Bridge, if you can picture where this is at. Now, the white PT Cruiser comes to a stop on its own volition. The driver comes to a complete stop without being ordered to do so by Officer Vickers. At this point, Officer Vickers had not activated his lights. He had not activated his emergency sirens. And so the officer sees this white PT Cruiser stop on its own accord on the top of the bridge. The white PT Cruiser is being driven by this defendant, John Jonchuck, Jr. Now, Officer Vickers gets to the top of the bridge and he sees that the vehicle is stopped, and so he immediately pulls alongside it. If you're going south in the Dick Misener Bridge, they're on the right side of the bridge. There's a short wall, and then there's the water below. So Officer Vickers pulls in about 15 feet behind the white PT Cruiser. He doesn't know what to expect at this point. The vehicle stopped on its own. A few moments later, Officer Vickers sees the defendant, John Jonchuck Jr., the man sitting right behind me, emerge from the driver's side of the vehicle. Officer Vickers at this point is expecting a confrontation because you'll remember he thought this was maybe a stolen vehicle. Never imagined what he was about to witness. The defendant exits his vehicle from the driver's side and walks toward Officer Vickers. At this point, Officer Vickers has his firearm drawn, ready for that confrontation. The defendant makes a statement. He says, "You," referring to Officer Vickers, "you have no free will." And then the defendant walks between the two vehicles and then around in front of Officer Vickers to the passenger side of his white PT Cruiser. He opens the door, and at this point, Officer Vickers believes the defendant is about to retrieve a weapon, a firearm. His gun is at the ready. He's been trained for this moment. The defendant goes inside of the vehicle, and instead of retrieving a firearm or a weapon, retrieves a child. A 5-year-old, blonde-haired little girl named Phoebe. Takes the child out of the vehicle. The officer can see she had just been awakened. She's clearly alive, a real child. The defendant takes her from the vehicle, turns, and then lets go. Drops her from a height of about 70 feet into the dark water of Tampa Bay. The officer heard her scream on the way down. So we know that she was alive. The defendant then goes back to the driver's side of the vehicle and flees. And that's important, and we'll talk about that later. But he flees. He knows what he has done. He has effectively murdered his child in that moment, and now he's fleeing. He goes south through that toll plaza. When he gets to the toll plaza, there are 2 lanes operating, lane 1 and lane 2. He goes to lane 2, but there's a few cars in front of him, and he can't wait because he's got to get out of there. He knows that not only he has committed this crime, but that an officer saw it. They're going to be looking for him, so he can't wait. So instead of waiting to pay the toll, he backs up, drives over some cones, goes through a closed lane to get out of there. Drives over the main span of the Skyway into Manatee County. And we'll get back to him in a moment. But first I want to talk about Officer Vickers, because his immediate focus is on this child. He runs to the edge of the bridge, he looks over into the water, and all he sees is blackness, darkness. I told you it's windy. It's extremely windy on the top of a bridge in those conditions, and the wind is ripping underneath that bridge. The water is choppy, and he never once sees the child in the water. If he did, it's likely he would have jumped, but he never saw her. So he immediately sees that there's a ladder at the top of the bridge. He climbs down the ladder. Now he's in full uniform. Remember, he just got off his shift, driving his marked police cruiser home. He goes down the ladder looking for this child. And you'll see pictures of the bridge in just a little while, and the ladder actually leads to a catwalk at the bottom of the bridge where he can go from east to west. And he does that. He's shining his flashlight in the water. He's calling out to this child, and he never sees her. No sign of her. By this time, he's radioed what has happened, so police officers from all over the city of St. Petersburg have heard this call that a man threw a child off a bridge. They're converging on that location as fast as they can. Some will go out across the Skyway looking for this man. Others go to the Dick Misener Bridge, and they began assisting Officer Vickers looking for this child. You'll hear that there was a helicopter in the air, the Coast Guard was notified, the fire department put boats in the water looking for this child. Officers were looking on the banks of the land to the north and south of the Dick Misener Bridge. Officers were looking over the bridge. They were in boats. Everything they could do to try and find this child. Eventually, she was found 90 minutes later, about a half a mile out into the bay, toward the Skyway. As I said, the water was going from, the wind was whipping under the bridge, but the water was going from west to east. We'll see that on the map. And that's the direction that her body went. When the body went over the side, west to east, out into the bay. And I'll show you that on some maps. One of the people looking for the child, or some of the people looking for the child, were Eckerd College students. And you'll learn that they actually have a search and rescue team because they have a university that's right there by the Dick Misener Bridge, and they put boats into the water to assist. And that's something that you'll hear they regularly do because of people who jump off the bridge from time to time. And unfortunately that does happen when people jump off the Skyway, and so they will go and they will assist. There was an Eckerd College boat that found Phoebe a half a mile out in the water. A group of college students who got a call in the middle of the night that they have to go and help. They find her body floating in the water. They call to other rescuers, and a fire department boat comes and meets up with them in the bay. They transfer the child from the Eckerd College boat from the hands of these students to the rescue professionals with the fire department. You'll hear that also on that very same fire department boat was Officer Vickers. He was determined to find this child that he saw go over that bridge. And he was actually on the boat assisting the fire department personnel looking for Phoebe. Officer Vickers tries to perform CPR on Phoebe. The fire department personnel are desperate to try and save her, but it's really no use at this point because she is dead. She'd been in the water for 90 minutes. She's cold to the touch. She's not breathing. There's no pulse. They never, ever have any signs of life from the moment that she's found in that water. It's clear at this point that she had already drowned. But you'll hear that fire department, rescue personnel weren't prevented by that. They continued to perform CPR on the boat. They brought Phoebe to O'Neill's Marina, which is right there at Pinellas Point, and that had become a staging ground for the rescue efforts. They had a Sunstar ambulance ready to go, and as soon as they brought her from the fire department boat to the marina, she was transferred to the Sunstar and taken to All Children's Hospital, where she was pronounced deceased shortly after by the emergency room personnel, when the emergency room doctor had determined that there was nothing that could be done. You'll hear from the medical examiner in this case. His name is Dr. Chris Wilson. He performed the autopsy on Phoebe Jonchuck. He will tell you that Phoebe died from drowning. There was no natural cause for her death. There was no physical trauma to her body that would have caused her death. There was no trauma to the head or anything else that would have caused this child's death. And he noticed that in her lungs there was a frothy liquid consistent with drowning. You'll see some photographs. They may be difficult to look at, but you'll see in the autopsy photographs that she has a bruise on her leg consistent with the fall. You'll hear that that bruise had to happen before she drowned because the body doesn't bleed once the body is dead. Now, if we go back to the defendant, John Jonchuck Jr., who did this, he has gone over the main span of the Sunshine Skyway Bridge, and when you cross the bridge, after you pass an exit to Palmetto, you have a choice. You can go south on Interstate 75 towards Sarasota, or you can veer left and go north back to Tampa. He's from Tampa. He had come here and he made that loop through Pinellas and decided to go back toward Tampa where he had come from. He's on Interstate 75, having fled this crime, going north toward Tampa, when St. Pete officers Jenna Gillis and Andre Sousa finally catch him. They had to go to extraordinary speeds to find him. And then they do, and they activate their emergency lights and sirens to pull him over. But he does not stop. Instead, he was so desperate to get away, he actually did a U-turn right in the middle of Interstate 75 after they had activated their lights and drove straight toward them. You'll hear from Officer Jenna Gillis. She'll tell you that she was in the center lane. The defendant made that U-turn and came right at her, and she had to take evasive maneuvers to avoid a head-on collision with this defendant. He continued to go south in the northbound lanes. Now, he is going the wrong direction on Interstate 75 down towards Sarasota at this point. Officer Sousa and Officer Gillis make their U-turns in the middle of 75, and they follow after him. At some point, for safety reasons, they actually get off and get back on Interstate 75 going the right direction, but the defendant continues traveling in the wrong direction, south in the northbound lanes. So Officer Gillis and Officer Sousa are now paralleling the defendant who's traveling in the wrong direction, but they are still following him because they're over here in the right lane of travel. You'll hear that by this time, the entire law enforcement community had learned that a man had thrown this child off the bridge. Florida Highway Patrol was involved, the Manatee County Sheriff's Office had been notified, and they're in Manatee County. So the Manatee County Sheriff's Office sets up a roadblock. They set up multiple police officers, multiple cruisers in his lane to force him to a stop. But what works is when they actually deploy spikes in the road to shatter his tires, to force him to come to a stop. You'll hear that officers deployed stop sticks. That's what these spikes are commonly referred to as. And they threw them out in the road. And they're called stop sticks because their spikes are actually on sticks that they deploy. His tires ran over the sticks, and that's what caused him to come to a stop. the vehicle rolls to a stop, essentially right in front of this massive roadblock of police officers. At this point, they have him. He's in his vehicle. He doesn't open the door when they come rushing to the PT Cruiser to get him out. He doesn't unlock it. He refuses to come out. And you'll hear from officers that they actually had to shatter the driver's side window to pull him out. And they had a little difficulty getting him out through that window because in spite of all that he had done, he still fastened his seatbelt for safety. They pull him out through the window, and then he is placed into custody and transported to the closest police department, which at that point was the Manatee County Sheriff's Office headquarters. Members of the jury, you will learn during the course of this trial that there is no question that the man sitting right here, John Jonchuck Jr., committed this murder of his biological daughter, Phoebe Jonchuck. Mr. Ellis explained to you in jury selection that we have two theories to prove this murder. The first is premeditated murder, and you'll learn that in order to prove a premeditated murder in this case, we would have to establish that, number one, Phoebe Jonchuck is dead, which is not being questioned. Number two, that death was caused by the criminal act of John Jonchuck Jr., which again, we will prove to you. And number three, that there was a premeditated killing of Phoebe Jonchuck. You will be told that as it concerns premeditation, killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing, and the law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. There's no set time in which that premeditation has to form under the law. But the period of time must be long enough to allow reflection by the defendant. He has to know what he's doing and has to have had reflected on it. And the facts of this case will prove that the defendant had time to reflect about what he had done when he stopped on the bridge of his own accord, exited his vehicle, went to the passenger side, pulled Phoebe out, and dropped her. The other theory that Mr. Ellis discussed with you in jury selection is that of felony murder. And you'll remember he gave the illustration of the arsonist who burned down the house, didn't intend to kill someone who had crawled in the house to get away from the cold. In order to prove felony murder, and keep in mind, felony murder is first-degree murder, the state would have to prove that, number one, Phoebe is dead. Number two, that while engaged in the commission of an aggravated child abuse, the defendant caused the death of Phoebe Jonchuck, and that the defendant was the person who actually killed her. In order to prove felony murder, you'll be told it is not necessary to prove premeditated intent. So the felony for this case, for felony murder, is aggravated child abuse. And just using your own common sense, you can all see how taking your child and dropping her off the side of a bridge would be aggravated child abuse. You'll be told that the definition of child abuse means an intentional infliction of physical injury upon a child or an intentional act that could reasonably be expected to result in physical injury to a child. The evidence will show that the defendant's actions were an intentional act reasonably likely to cause physical injury, and we know in this case his act caused her death. Now, I expect that in this case, as you've already been told, the defense will argue that the defendant was insane at the time that he committed this murder. And I want you to keep in mind that the defense has to establish that by clear and convincing evidence. You've been read a jury instruction for insanity, but I'm going to read it to you again because it's important, and we need to consider it. And we need to consider carefully what these words say. A person is considered to be insane when he had a mental infirmity, disease, or defect. But the analysis does not stop there. Someone is not insane just because they have mental illness, just because there's something wrong with them, or they may say things that sound strange. Number two, because of this condition, he did not know what he was doing or its consequences. To be insane, John Jonchuck Jr. would not know what he was doing at the time that he dropped Phoebe off the bridge. If he believed he was doing something else, anything else, but the evidence will show that when the defendant, John Jonchuck Jr., dropped his child off the side of that bridge, he did know that he was killing his child. He did know what he was doing. He knew the nature of his act. And there's an or. The second part of that is because of this condition, he didn't know what he was doing or its consequences. Or, although he knew what he was doing and its consequences, he didn't know it was wrong. This is what you have to consider for insanity. And members of the jury, the evidence in this case will show that the defendant not only knew what he was doing when he killed his child, but that he also knew it was wrong. And therefore, he was not insane. Everyone is presumed under the law to be sane, and the defense has to prove to you by clear and convincing evidence. The defense has the burden of proving the defense of insanity by clear and convincing evidence, and that is evidence that is precise. When you consider the defense evidence in this case, I want you to ask yourself, is this evidence that's being presented to me for insanity precise? Is it explicit? Is it lacking in confusion? Because that's the standard. And it has to be of such weight that it produces a firm belief without hesitation about the matter. That's what the law says. And I would submit to you that if you hold the defense to that burden of clear and convincing evidence, they will not meet that burden in this case. Because the defendant was sane and knew exactly what he was doing when he committed this murder. The defendant fled the murder. He knew what he had done, and he knew he needed to leave. He knew that what he had done was kill his child, and he knew that it was wrong, which is why he had to flee as quickly as possible. There will be experts who will testify in this case, experts for the state, experts for the defense. It would be easy to look at the evidence and say, well, this sounded a little strange. Well, he did that. That sounds a little bizarre. Therefore, must be insane. That would be an easy way out. I ask you, members of the jury, to look deeper into this case. Look beyond the superficial. To really look at the evidence and to look at what these experts are saying. Look at the nature and quality of the evidence. You'll hear that the experts in this case reviewed thousands of pages of documents, police reports, depositions, that they all interviewed the defendant, and he gave an account. You'll hear that his account of what happened varies from doctor to doctor, that there are discrepancies and inconsistencies. You will not hear any evidence that he was diagnosed with schizophrenia before this murder. I'll repeat that. You will not hear any evidence that he was diagnosed with schizophrenia before this murder. He had seen a psychiatrist, a man named Dr. Arthur, from 2011 to 2013. And in that time, he had been diagnosed as being bipolar, of the more depressive type, and he had an early childhood history of attention deficit disorder. You're going to learn during the course of this trial that Phoebe Jonchuck was his biological daughter, that she was born out of a relationship that he had with a woman named Michelle Kerr. They were never married, and they had a tumultuous relationship. And at some point, he took the child away from Michelle Kerr, and Phoebe lived with him. And wherever he went, he would take Phoebe with him. And he would keep Phoebe away from her mother, Michelle. Phoebe was born on August 22nd, 2009. And shortly thereafter, maybe a couple of years, after an on and off again relationship, the defendant and the mother separated. You'll hear that the defendant received Social Security money for having custody of Phoebe. And you'll hear more evidence of that. You'll hear that during this time, during this relationship with Michelle Kerr, that the defendant was not psychotic, meaning he did not have delusions, he did not have hallucinations, that there were no mental health issues regarding Mr. Jonchuck of psychosis, which means if you have psychosis, you are out of touch with reality. You don't know where you are, who you are, what you are doing. An altered or delusional view of reality. There's no evidence of that during this time period. You'll learn that after this on-again, off-again relationship with the child's mother, that on Thanksgiving Day, 2014, the defendant and Phoebe met with the child's mother, Michelle, and her new boyfriend at Denny's. They went there for Thanksgiving dinner. You'll hear that everything was fine. It was apparently a nice Thanksgiving dinner for them. Nothing fancy, but no serious concerns for his mental health. But at this point, the defendant realizes that the mother, Michelle, has a new boyfriend. His name is Guy Kisser. She's starting to get her life together. He has a job. He can provide. They have a place to live. And suddenly, she has the ability to get Phoebe back from him. The defendant sees this as a threat. That fall, in August, shortly before the Thanksgiving dinner, he actually went to an attorney who may testify in this case. Her name is Genevieve Torres. He went there for a consultation regarding getting custody of Phoebe. It wasn't really an emergency for him at that point because this was in August prior to that Thanksgiving dinner, but he was of sound mind when he sat down with that attorney and he discussed his rights and the fact that he wanted custody of Phoebe. So when they have the Thanksgiving dinner, things are now different. There's a new guy in the picture. There's a threat to him having the child, to the Social Security money that he is getting from having this child, and from being able to use this child as a way to get into people's houses so that he can always have a place to stay. And you'll hear more about that. December 24th, 2014, Phoebe's last Christmas. They go again to the mother's house. This time it's the defendant, his own mother, who's also named Michelle, and Phoebe. They go to the home of the child's mother, Michelle Kerr, and again, she still has the boyfriend there, Guy Kisser. Michelle, the child's mother, thinks John has changed. He's being nice to her. He's letting Phoebe come over and spend time with her because up until this point, he only let the child's mother see Phoebe when he wanted to, when it suited him. But now, she thinks things are better. They actually had a nice Christmas Eve dinner together. But underneath the surface, what she doesn't realize is that things are simmering with this defendant because he sees the likelihood that he's about to lose this child. After Christmas, everything falls apart. He's afraid of losing her. He sees Guy Kisser as a threat, and they began exchanging heated text messages about him getting custody of Phoebe. He's hired a lawyer. He's going to take and keep Phoebe, and she's never going to be able to see Phoebe again. The text messages continue through New Year's Eve and into New Year's. On New Year's Eve, he's so eager to get full custody, legal custody of Phoebe, and he sees Michelle Kerr as such a threat that he's actually sending emails to that attorney saying that he wants to get the paperwork going for custody. On New Year's Day, he emails the attorney again, and they set up an appointment in her office for January 6th, just a couple days before the murder. Now, also during this time, it's important to talk about what's going on with the defendant's biological mother. I told you her name is Michelle as well. So during Jonchuck's life, Mr. Jonchuck's life, his mother was not really there for him. She was in and out of jail. She had her own drug issues. He basically grew up without her being around. But now that Phoebe had been born, she's got her act together. She's got a reason to live and someone to live for. And so she's spending a lot of time with Phoebe. This is her granddaughter. And at Christmas time, she showered Phoebe with Christmas gifts. Her family and her side of the family showered Phoebe with all of these Christmas gifts. And the defendant was jealous. Here's this woman who wasn't there for him giving all of this to Phoebe. So we've got some different dynamics going on that are important to this case. And on Monday, January 5th, 2015, the defendant goes to his mother's house where Phoebe had been staying for the last few months, and he grabs her. He takes her away, brings her back to his dad's house where he was staying, and he tells his mother 2 days before the murder, in his own words, "I'm going to do something to fuck up your life." The next day, Tuesday, January 6th, he goes to his law firm, sits down with this attorney, Genevieve Torres, and they actually come up with the custody paperwork together. No mental health issues, no mental health concerns. They were able to sit down together and actually draft what would be a petition so that he can have paternity, and he's able to give her information, and they're talking back and forth. And there's no indication to her that there's something wrong with him at all, because there isn't anything wrong with him. She's so convinced, and rightly so, that there's nothing wrong with him, he signs the contract. But it's not, and he signs the actual paternity paperwork that's supposed to be filed in court. But she doesn't file it yet because he has to return to pay the filing fee. Monday, January 7th, 2015, the day before the murder. The defendant goes back to Genevieve Torres' law firm at 10:51 in the morning. He says some strange things to her, and we don't hide those from you, and we're not going to run away from those. He says some things that sound pretty weird. But after he's done talking to Ms. Torres, he says something that's very important. He says, "None of this will matter anymore," and he leaves. Members of the jury, paternity always matters. As long as Phoebe is alive, it matters who has custody and who her father is and who her mother is. He told Genevieve Torres that he was going to a church to be baptized. She was concerned about some of the strange and bizarre things that he had said to her. And so she called 911, especially after he said on the way out the door, "None of this is going to matter anymore." She's concerned for Phoebe, and rightly so. So she calls 911 and tells the dispatcher that he's gone to St. Paul's Catholic Church to be baptized. The defendant goes and he meets with a Father, William Swingros, who's the head priest at St. Paul's Catholic Church on Dale Mabry in Tampa, not far from where the law firm was. He says some things to him that are a little out there, but again, nothing that would meet the definition of insanity that we are discussing. It's easy to look at some of these statements and say, wow, that sounds crazy. But I would tell you the word crazy is not in the law and it's not in these jury instructions. The analysis is, did he know what he was doing? And did he know whether it was wrong? He tells the priest that he's the Pope, and that's rather bizarre. But then the priest says, you know you're not the Pope, right? And he goes, yeah, you're right. I'm not. So you'll see that here we have someone who is fully capable of knowing what's going on, what's happening around him, and he's in the here and now. He knows what he's doing, where he's at, what he wants, and why he's doing it. When the deputies from the Hillsborough County Sheriff's Office arrive, they do what's called a Baker Act evaluation. And some of you may know what that is. The deputy's trying to find out, is he a threat to himself? Is he a danger to someone else? And they ask him questions, and pretty poignant questions at that. They ask him, hey, we heard some things from this lawyer that kind of concern us. For example, you said that the attorney, Genevieve Torres, is God. Do you want to explain that to us? And he says, well, you know, attorneys, they're like God. They think they know everything. A pretty coherent answer for someone who's in the here and now and knows what's going on. Well, the attorney said, none of this is going to matter anymore. Well, that's because the mother of the child got arrested yesterday, so, you know, this is not really going to make a difference. So we have a man who is not psychotic, as he might want people to think, but he's in the here and now, and he knows what's happening. He knows what's going on. You'll hear that he goes to a few other places. He meets with another reverend at St. Lawrence Catholic Church. He goes back to meet Father Swingros again with his stepmother and Phoebe, asking to be baptized. And then he goes to a final church, Lake Magdalene Church, looking to be baptized. That's what he wants, but no one will give him a baptism on the spot. That night he has dinner with his father, his stepmother, and Phoebe at his father's house. That's where he was staying, and that's where he brought Phoebe from a couple nights before. You'll hear from these family members. You'll hear from his father. You'll hear from his mother. And they will tell you that he was not psychotic that night, as best as they can describe it, for being, people who are not psychiatrists or psychologists. His father made scrambled eggs. They had breakfast for dinner that night. Phoebe was there. She enjoyed her dinner. When his mother, the defendant's mother, came over, she wanted to get Phoebe, but Phoebe wanted to stay with her dad. And so that's what they did. They stuck to the plan. Phoebe stayed with her dad. He had a plan to go to work the next day. He had a job as a chef at a Jamaican restaurant. And he told his mom, I'll take Phoebe to school tomorrow before I go to work. This is not someone who is psychotic. His mom gives him $100 so he can pay the attorney the filing fee so they can get that paperwork filed. You remember that paperwork had not been filed yet, and the family was aware of that. The mother of this defendant didn't have any concerns about letting Phoebe stay there. Had she had those concerns, she would have taken Phoebe. 8:27 that night, the defendant emailed his attorney and said his mom would drop off the $100 tomorrow. At 9 o'clock, he drives with Phoebe to see a friend named Noemi Bresnahan at the Oakwood Apartments. And he takes Phoebe with him, out in the cold, 9 o'clock at night. He's texting Noemi back and forth. She may testify. You'll hear about those text messages. He wants to stay with her. He's being manipulative with her, but she rejects him. And some of those text messages are odd. But she rejects him. And that, for him, is a final rejection. He comes home again. 10:25, he emails the attorney again, said he'll be at the law office in the morning to pay the $100, not his mother, because you'll recall his mother had given him that money. At 10:30, he called his mother and said he wanted to bring Phoebe over to her house. Changed her mind, let Phoebe spend the night at her house. And to this day, she regrets that she had not taken him up on that offer. But she said, no, John, we made a plan already. You're going to take Phoebe to school in the morning, then you're going to go to work, so let's stick to the plan. Besides, it's cold outside. There's no reason to change the plan. We think he left his father's house for the last time sometime after 10:30. It was just after midnight when he passed Officer Vickers. It would have been the first few minutes of January 8th, 2015. The defendant was 25 years old when he committed the murder. Phoebe was 5 years old. If I could go back now to the Manatee County Sheriff's Office. You will remember that I told you that after he was arrested, he was transported there. And when he was transported there, he was placed in an interview room. And fortunately for us, they had cameras in the interview room that documented his interaction with people coming in and out of the room, with police officers. You'll see in that video, again, that he does say some things that are a little off the wall, but he's in the here and now, and that's what's important. He knows who he is, he knows where he is, he knows why he's there. And at one point, he asks a detective, "How's Phoebe?" And this detective, he doesn't know who Phoebe is. He's a Manatee County Sheriff's detective who's thrown into this in the middle of the night. He says, "Who's Phoebe?" He may have had some understanding that that might have been the child, but he said, "Who's Phoebe?" "Phoebe J. Jonchuck. She was my daughter." He knows what he had done. He's talking about her in the past tense. He knows that he had killed her. You'll also hear that he had a friend named Melody Dishman. And at some point in his friendship with Melody Dishman, he had told her...
There's objection. May we approach?
Yes.
You're going to hear, members of the jury, evidence from some of the experts that the defendant heard voices telling him that he and Phoebe needed to both die or the world would go to hell. But you'll note that only one person went over the side of that bridge, members of the jury. And I ask that you consider that when you hear the evidence in this case. You will hear from state's experts who will tell you that the defendant does suffer from a personality disorder known as psychopathy, which is an extreme variant of antisocial personality disorder. Both of our experts have diagnosed the defendants with antisocial personality disorder, and that they will testify that that was the driving force, the driving motivation for this murder of Phoebe Jonchuck. You will learn that antisocial personality disorder involves characteristics such as impulsivity, someone who's impulsive, someone who is callous and lacking in empathy, and that psychopathy is the most extreme form of this antisocial personality disorder. Members of the jury, we are confident that with the evidence in this case, you will see that the defendant, John Jonchuck Jr., committed this murder to punish his mother and the mother of Phoebe Jonchuck. He told his own mother 3 days before the murder that he would fuck up the rest of her life, and he made good on that promise. That little girl was the only light that she had, and he struck at her heart when he killed that child. The mother of that little girl, Michelle Kerr, wanted her back, and he knew that he stood to lose her now that she was stable, had a boyfriend with a job and a place to stay where Phoebe could live with them. He was threatened by that. He was threatened with losing the Social Security money that he received for having Phoebe. And in one act, he struck at both of them to punish both his mother and the mother of Phoebe. When he committed this murder, he was angry. His world was falling apart. He had been rejected. When he went to his friend Noemi's house that night, it was a final rejection, and he was enraged. He acted impulsively and committed the one thing, did the one act to hurt as many people as possible. He did it in front of a police officer because he was so angry and so enraged, he didn't care. And then knowing that he had committed this murder, he fled as fast as he could. Members of the jury, the defendant was sane when he committed this murder. He's presumed sane today, unless shown to you by clear and convincing evidence otherwise. He was sane when he committed that murder. He is the one who did it, and we are asking that you hold him responsible for it. There is only one verdict that speaks the truth in this case, and we believe that if you follow the evidence, if you apply the law, and you apply your own common sense, you will return the only verdict supported by all three: the evidence, the law, and your common sense. And that is a verdict of guilty of first-degree murder for the death of Phoebe Jonchuck. Thank you.
What happened just after midnight on January 8th of 2015 was tragic. That night, John Jonchuck Jr. took his daughter, whom he loved more than anybody in the world, and dropped her over the side of the Dick Misener Bridge. It didn't make sense at the time. It doesn't make sense today. It will never make sense because it is insanity. You are going to hear so much evidence in this case in the form of witness testimony. You will see it in the form of records. You will hear from lay witnesses. You're going to hear from law enforcement officers. You're going to hear from mental health professionals using psychiatric terms, describing psychiatric medications and psychiatric treatment. It's going to be a lot of information. And thank you so much for all returning. Both sides really appreciate that you have returned and are committed to giving this case the attention that it requires. This case didn't start in January of 2015. Unfortunately, Mr. Jonchuck has struggled with mental illness since he was a small child. From about the age of 5, he is being seen by mental health professionals at the University of South Florida. And unfortunately, for Mr. Jonchuck, mental health treatment was never the focus of the adults in his life. Now you'll hear that from 5 years old until about 14, he was going to USF to receive treatment for something having to do with his psychiatric state. He was receiving counseling. He was prescribed medications. But oddly enough, none of his family can really tell you about that. Nobody knows who was taking him to these appointments. Nobody really knows what the diagnosis was. They know that they were giving him the medications, but couldn't really tell you why. And so unfortunately, at about age 14, that was no longer a priority, making sure that John got the mental health treatment that he needed. From a very young age, John was kind of treated as a hot potato. Mom struggled with her issues in the criminal justice system, with her drug addiction. She dumped John on Dad at about age 2. Dad had to go up to Tennessee to take care of some business, so he dumped John on uncles. At some point, Dad comes back, and uncles dump him back on him. And while John was living with his father and stepmom, he spent a great deal of time with his uncles over the weekend. And so they'll tell you they were administering medication, Adderall, Klonopin, he thinks, but doesn't know why he was giving it to him at such a young age. You'll hear that the records from USF, unfortunately, have been destroyed due to how old they are. And so we'll never know exactly what was diagnosed or prescribed or the treatment that was provided back then. At about 16, John's trying to form a relationship with his mom again. Mom's out of prison, she's on probation, she's in and out of his life, and he's having some behavioral issues, which you'll hear is not unusual. In fact, it's very common with children and adolescents struggling with mental illness. And certainly, you can understand that the less support and understanding they have coming from the family, obviously, the worse it's going to be. And at age 16, John's dad says, you know what, I don't want him anymore. Just take him, State. Just take him. And so he began living with friends until he met Michelle Kerr, and they moved in together when he was 18 years old. At 21 years of age, John seeks out mental health treatment on his own again. He goes to a man named Dr. Arthur. You're going to hear that 21, that is an age that is consistent with a lot of the symptomology of mental illness making an appearance. And when he's 21 years old, he goes to the doctor and he says, I can't hold the job, I can't focus, I can't control my emotions, I'm struggling. He was diagnosed with bipolar disorder, with severe anxiety, with attention deficit disorder. He was prescribed medication upon medication in different combinations. Abilify, Xanax, Zoloft, Seroquel, Wellbutrin, Ambien, Keppra, Gabapentin, Adderall. Different combinations, always trying to tweak it, trying to figure out what can help this gentleman survive and deal with his illness. He, at this point, is a young man with little family support, struggling with mental illness, struggling with keeping a job, with keeping insurance, to stay on track with his medication. And so you're going to hear that he stopped going to see Dr. Arthur in 2013 and was using his medication sparingly to try to spread it out and make it last. In fact, September of 2014, you'll see that he tried to get his prescription, an old prescription of Seroquel filled. Something that's used to treat, an antipsychotic used to treat mood disorders. In September 2014, he was trying to get filled. And so for the most part, John managed. He had Phoebe when he was 19 years old, and it was a tumultuous relationship, he and Michelle's. No one's going to deny that to you. They both have mental health issues. They both had a lot of stress with raising a young child. It wasn't a healthy relationship for either of them. But one thing is certain, he loved Phoebe more than anybody. There's nobody that will tell you that's not the case. The state has asked you to believe that John killed his daughter because he was afraid of losing her to Michelle. Now you're going to hear that Michelle had 2 kids prior to having Phoebe. And her custody arrangement with her ex was, you keep 1 kid, I'll keep 1 kid. Michelle received benefits for Phoebe and had not seen her in a year, had not attempted to go to court to make contact with her, had not contacted law enforcement to make any allegations that John was keeping her from his daughter. So the actual threat of Michelle Kerr coming to take Phoebe doesn't make sense. And while John may have felt threatened, I submit it was because of his psychosis. It doesn't match the evidence. It doesn't match the facts or the history. Something happened. It doesn't make sense, and it will never make rational sense. He's maintaining, he's getting along. Okay. And what caused this psychotic break in December of 2014? Because the evidence will show you there was a break with reality. Something happened. In November, the end of November, he goes to Thanksgiving dinner with Michelle Kerr, her fiance, Phoebe, his mother. Everything is fine. In fact, there's a couple more visits around that same time. By Christmas Eve, they get together again. And Guy Kisser, Michelle's fiance, says she notices John outside talking to himself. Something is happening. By December 29th, 3 a.m., he's in the emergency room for severe anxiety. Doesn't remember being in the emergency room, you'll hear. But the doctor writes that she tells him he's having an anxiety attack, and he argues with her about it. Which seems inconsistent if somebody was setting up an insanity defense. It's 3 in the morning on December 29th. December 29th, at 8 a.m., December 30th, 8 a.m., he calls in a complaint to DCF. He says that Michelle and Guy Kisser, they're chasing the kids around with a hammer, there's drugs all over the house, all kinds of complaints why the kids aren't safe. And then just a few hours later, DCF comes out and talks to him about that. And he downplays all those concerns. Then the very next morning, bright and early, on October 31st, he's filling out a petition for an injunction. He's asking that Michelle Kerr not be allowed to have any contact with him and or Phoebe. It's not really clear. You'll get to see the injunction. You will see how his handwriting, it looks as though 4 to 5 different people wrote the paragraph. Something is happening. We know from early on when he was seeing Dr. Arthur that his anxiety gets worse at night. And we know that he's struggling at night. Is it the stress? You're going to hear from the mental health professionals that say stress is a trigger. Stress can push somebody over the edge. You have the diagnosis, and it can push you. Michelle had recently come back along, and if you just look at the actual facts, it actually seems like everything's going smoothly. Michelle's coming along, Guy Kisser is around, they're getting along when they're all together. But was there some underlying stress, underlying fear, unrealistic that Michelle Kerr was going to come in and take Phoebe back? Maybe. His living conditions weren't the best. You'll hear that he's sleeping on his father's couch. Phoebe's sleeping in the room. That's stressful. You'll hear that he wasn't sleeping the week leading up to this. And that's something that he had struggled with for years, but he hadn't slept for days on end. And you'll hear from the mental health professionals what that can do to somebody's mental state. It will never make rational sense because it is insanity. Now, on January 7th of 2015, John starts his day by calling St. Paul's at 1:30 in the morning. By 10 o'clock, he is at Genevieve Torres' office. Now, Ms. Torres will tell you just the day before, January 6th, he was in there and normal, whatever that means. And his behavior had changed so drastically from when she saw him on January 7th until when she saw him in the morning of January 8th that she began alerting officials. She called the sheriff's office. She called 911 and said, "This man was just in my office and I am concerned he needs to be Baker acted. I don't think he's under the influence. I don't think he's drunk. He's not making sense. He's rambling. She was so concerned by the behavior that she observed that she calls the sheriff's office when they say they're not doing anything. She calls DCF when they tell her they're not doing anything. She sends her employees home and closes her office early. He insists, because she's just gotten back from vacation, that she actually was back from Babylon. He tells her she just returned from Babylon. He insists that she's Saint Genevieve. Miss Torres corrects him and says, no, I'm not Saint Genevieve. Well, then you must be God. He's all over the place. It makes no sense. Despondent and strange, she repeatedly says. And he says, I got to get to the church. I'm sorry, let me back up. He's got his Bible, this giant Swedish Bible that he's been lugging around. For about 4 days now, he's taken it everywhere he goes. He's slept with it under his pillow. He carries it everywhere. He insists that it is knocking at him. He is obsessed. This Bible came from his stepmom, and you'll hear that she tried to get it back from him, and he wouldn't give the Bible back. He became obsessed, which was also unusual because up to that point, he'd never been a particularly religious man. They weren't a particularly religious family. But all of a sudden, he has this obsession. And so he takes the Bible, he has the Bible with him when he's speaking to Miss Torres, and he insists that she read it. She explains that she can't because she doesn't speak Swedish, and he insists that she does. And she's God, and she must. He then says he has to get to the church by 11 and asks her to keep Phoebe for him. Of course, Miss Torres said, well, I can't keep your daughter for you, and sends him on his way. Instantaneously realizing that something is off. Something is wrong. By about 11:15, John's at St. Paul's. And there he demands an exorcism. He indicates that he's possessed. Within seconds later, he's demanding he be baptized today. He's the Pope. No, sir, you're not the Pope. Oh, you're right, of course I'm not the Pope. But then I'm God. It doesn't make sense. He's convinced that Father Bill attempted to take this Bible from him. At some point, the deputies make contact with him. Hillsborough County deputies respond, and they make contact with Mr. Jonchuck. And unfortunately, they were there for the very, very limited purpose of conducting a Baker Act evaluation. Whether he was an immediate threat to himself or somebody else at that time. And it's not clear what John believes they were there for, but he certainly answers the questions under the belief that they are somehow there investigating his fitness to be a father. Everything's fine here. There's no problems here. In fact, they ask him about his mental health history, and he says, well, I used to be bipolar, but I'm not anymore. Denies that he has any mental illness. They make the observations. They don't believe he's under the influence. Phoebe looks happy. She doesn't seem scared. And they send him on his way. By noon, John's already at another church. He's now at St. Lawrence, speaking with Reverend Caesar Patia, demanding an exorcism. Says the devil is everywhere. He sees the devil everywhere. And he needs information about exorcism. And unfortunately, Reverend Patia says that's above my expertise and directs him to another church. By 1:30, we know that John is at Lake Magdalene, a third church for the day. And this time he has his stepmother in tow. You'll hear from Father Bill that he actually went home, got his stepmother, and came back. And for some reason was convinced that he had to show Father Bill his stepmom was alive. Which Father Bill will tell you, I never questioned that. That wasn't something that we talked about, whether she was alive. But John's convinced he needs to show Father Bill proof of life on stepmom. So he drags her back to the church with him. And then they go to Lake Magdalene. Same situation. He walks in, he's demanding to be baptized that day. Everyone is trying to explain to him that's not how this works. But he's desperate. In the week leading up to this, all kinds of things started happening. January 3rd, he starts sending text messages to his uncle that he hasn't spoken to in years. He's telling them that the Chinese drywall is making the food taste funny, and that Phoebe is having panic attacks and waking up wailing in the middle of the night. They're bizarre messages. He says, I found the key to unlock my gift. I am going to do everything I can to get him out of there. Things that just don't make sense. He starts calling an ex-friend incessantly, sending text messages and leaving voicemails, telling her that she's possessed by demons. Now, unfortunately, the police chose to never collect these text messages. So while we have the police officer confirming that he sent them by speaking to the witness the day after, we will never actually get to see them. He starts pouring salt around the house. In fact, when the officers go to his house to give the death notice, as they're approaching the house, it looks like ant killer around the house. A piled along of salt. When they enter the house, Dad and stepmom say, oh yeah, he's trying to keep the demons out. He explained to us that he needs to salt the house and Phoebe's room. There's salt also outside the room that Phoebe's sleeping in, because he's trying to keep the demons away. This is unfortunately something you also won't get to see because the police chose not to take photos of any of this. He restarted reporting to people that he was possessed, that Phoebe was possessed, that Phoebe, when she put her hand on the Bible, she would start chanting. and that the Bible was knocking at him. It does not make sense. After leaving Lake Magdalene, John goes home, back to his father's house. And despite their efforts to suggest that John did something to hurt Phoebe, he had called his mother that night and asked her if she wanted to have Phoebe stay with him. In fact, John's mom will say she came over that night on January 7th because John had called her and said, come pick up Phoebe. She's going to stay the night with you tonight. When she got there that night, she noticed that Phoebe was wearing a gold cross necklace. This was a necklace she hadn't seen in years. It was a necklace that her brother, John's uncle, had given to him when he was a small child. And it all of a sudden had reappeared, and Phoebe was wearing it now. She noticed he had the Bible under his pillow when she was out there talking to him, and Phoebe didn't want to go with Grandma. Phoebe wanted to stay with her dad that night. And so she left. At 9 o'clock, we know that John is at an old friend Noemi's. And he's pacing outside with Phoebe by the hand. And the neighbor said it just didn't look right. He was pacing. They didn't seem dressed appropriate for the weather. I almost called the police myself because it was just so bizarre. Noemi says, he's sending me these bizarre text messages all of a sudden. All of a sudden, he's sending scripture and strange sounding messages, and he had never been a religious man. He was professing his love for her. And you will hear that this was a completely platonic relationship. Neither of them had any thoughts one way at all like that. So it was especially strange all of a sudden. And he tells her, sends her a text and says, we're meant to be together. Think on it overnight. And she's like, well, this is weird. This is very unusual. I'm not going to open the door and talk to him because he's acting so strange. Unfortunately, you won't get to see those text messages either. Because although Noemi told the police almost immediately that she had received some very strange text messages, the police chose not to collect them. On January 5th, the state mentioned the fight in the middle of the night, where he says, I'm going to ruin your life, or I'm going to do something to ruin your life, to that effect. John woke up his mother and Phoebe from stone cold sleep. Everyone was asleep that night. There were no issues. He woke him up in the middle of the night on January 5th, demanded that Phoebe and his young cousin come with him, get in his car, and starts yelling at his mother, talking to her as though she is Mom's mom, or as though he is. So he is saying things to his own mother as though he is her mother. It doesn't make sense. Now by 10:30, now we know so John sends an email and says, Mom will be by with the rest of the money. before you close. But he sends that well after closing. And then he sends an email at 10:30, so after Noemi's house, telling her, we'll be by in the morning with the rest of your money. We'll be by in the morning with the rest of your money. That's at 10:30. His dad hears the door open and close sometime between 10:30 and 11. We know that at about 11:58, he is speeding through a red light at the intersection of Kennedy and West Shore. Not even yielding for traffic. Barely missing, causing an accident.